The clerk will now proceed to read the orders of the day.
Sentencing Guidelines Pre-Sentence Reports Bill. Committee.
No.
Order. Order.
Sentencing Guidelines Pre-Sentence Reports Bill.
Can I remind members that in committee, members should not address the Chair as Deputy Speaker. Please use our names when addressing the Chair. Madam Chair, Chair and Madam Chairman are also acceptable. We begin with Amendment 1 to Clause 1, with which it will be convenient to consider Amendments 3, 2 and 4, the questions that Clauses 1 and 2 stand part of the bill, and new Clause 1. I call Sir Jeremy Wright to move Amendment 1.
Thank you very much, Madam Chair. May I begin by begging to move that Amendment 1 be moved in my name and speak to that amendment, and indeed to Amendment 2, which is consequential on it, and to one of the other amendments in the group. Madam Chairman, I think it's worthwhile at the outset of all debates on this bill restating that the bill is about pre-sentence reports, which give information to sentences which may be used in sentencing decisions, not about the passing of sentences themselves. Specifically, this bill is about the guidelines issued by the Sentencing Council to sentencers about the circumstances in which a pre-sentence report should normally be asked for, and about the sort of information about an offender which such a report may provide and which it may be appropriate to consider and take into account before deciding on an appropriate sentence in that offender's case. Now, Madam Chairman, there has been broad agreement. I see the Mother of the House in her place, so I will not say unanimity. Broad agreement that an offender's ethnicity, race, culture or faith are on their own not that sort of information, and that the Sentencing Council was wrong to suggest that pre-sentence reports should be ordered on that basis. Now, I would argue that is because even if there may be points to make about the treatment or experience of members of the ethnic, faith or cultural group to which the offender in question happens to belong, what is relevant to the sentencing of that offender can only be the treatment or experience to which the particular offender has themselves been subject, not whether they've arisen in the cases of other members of the same group who are not before the court. That is effectively the impact of Amendment 4 in the name of my honourable friend, the Shadow Minister. And that is why, in my view, the government is right to seek to exclude, even from the process of asking for a pre-sentence report, let alone from passing sentence itself, the making of decisions based only on membership of such a group. And that is, after all, what the government has said this bill is for. Now, these groups are described in the explanatory notes to the bill as particular demographic cohorts. And if I may, I want to quote from paragraph 8 of those explanatory notes. What paragraph 8 says is that the bill is intended to ensure that sentencing guidelines are drafted in such a way as to prevent differential treatment and maintain equality before the law. It does this by preventing the creation of a presumption regarding whether a pre-sentence report should be obtained based on an offender's membership of a particular demographic cohort, rather than the particular circumstances of that individual. But despite, Madam Chairman, this explanation in the explanatory notes, the bill, I think, goes further than that, prohibiting the Sentencing Council from including in a sentencing guideline any provision, and I quote, framed by reference to different personal characteristics of an offender. That's what Clause 1, Subclause 2 says, inserting language into the Coroners and Justice Act of 2009. Now, I think that language in the bill is significantly wider in impact than reference to membership of particular demographic cohorts, and in my view, undesirably so. And that is why I've put forward Amendment 1, which would adopt the language used in the explanatory notes. And Madam Chairman, let me explain why I think that would be preferable. My starting point is that I don't believe all personal characteristics of an offender are inappropriate to consider in a sentencing decision. There is, of course, much more to be considered in a sentencing decision than simply information about the offender, in particular the seriousness of the offence and its consequences. But relevant information about the offender is needed as part of the process. It can't then surely therefore be right to prohibit the Sentencing Council from encouraging sentencers to find out more about some of those personal characteristics which are relevant in reaching a more informed and therefore a better sentencing decision. For example, a physical or learning disability, or a brain injury from which an offender will not recover. Now, the relevance of that information is not just in forming a fuller picture of the offender to be sentenced, but also in assisting a sentencer to know whether that offender is capable of carrying out aspects of a community order, including work in the community, which the sentencer may want to consider as a potential sentencing option. And it's worth underlining, of course, that the ordering of a pre-sentence report, whatever it says when it's produced, does not bind the hands of a sentencer to do as it recommends. But the reality is that without one, a sentencer's options are often more limited. And that's why guidance on when to ask for a pre-sentence report matters.
Will you give way on that point?
Of course, I give way.
I'm very grateful to my honourable friend giving way, and I defer to his experience, but there is an argument, therefore, if we're looking at individual cases, for every individual to have one of these pre-sentencing reports, to be able to then truly understand the significance of what they've faced, whether any other mitigating factors. I appreciate that could put a backlog on the services themselves, but is that not one possible solution to solve the problem that the Sentencing Council were worried about different cohorts having different sentencing outcomes at the end?
Well, I think my honourable friend makes a fair point in relation to those offenders who hover on the border between community sentences and custodial sentences. But he will know that in the Crown Court, at least, the majority of such offenders already do have a pre-sentence report. But of course, there are also offenders who come before the courts for sentencing where either it's blindingly obvious that a custodial sentence will follow, or that neither a community sentence nor a custodial sentence is realistically in prospect. So I don't think it would be right to say that in every case we should have a pre-sentence report. But I do think that there is a presumption already in the law that pre-sentence reports should be ordered unless it's unnecessary to do so. What we're seeking to do here, I think, is respond to a very specific set of circumstances that have arisen as a result of a Sentencing Council decision. And as he may have heard me say at second reading, I don't think that the Sentencing Council have handled this well. And as a result, I think we are having to do something which otherwise we would not have to do. But, Madam Chairman, sentencing offenders in all circumstances is a difficult business. And the fact that different offenders receive different sentences, even for the same offence, is not necessarily evidence of a defect in sentencing practice as a result of guidelines or otherwise, but is more likely a reflection of the reality that every case and every offender is different. We should not, I suggest, be trying to stop judges reaching the appropriate conclusion, assisted by Sentencing Council guidelines, in each case before them. Give way.
Nobody is trying to stop judges sentencing in an individual case. All the Sentencing Council was seeking to do was to make sure that judges and magistrates had the maximum amount of information before coming to a decision on the sentence.
Yes, well, I think the Right Honourable Lady is right that that is what the sentencing guidelines were aiming at. I'm afraid, however, the way in which they were phrased rather missed the mark, in my view. And I think it is perfectly true to say that it is a good thing in most sentencing cases to get as much information as you can possibly have. But of course the sentencing guidelines, as she will appreciate, have particular influence on sentencers because sentencers are obliged to follow them unless it's not in the interests of justice to do so. So the tone that is set by the Sentencing Council in the guidelines that they draft gives a good indication to sentencers about the sorts of things they ought to take into account in sentencing. And as you heard me say, and I think it's an important point to make, we are talking about the ordering of pre-sentence reports and not of sentencing itself. But nonetheless, as I said, if you don't have a pre-sentence report, you limit the number of options that you can impose. And similarly, if you do have a pre-sentence report, you give yourself more options as a sentencer. So it's not irrelevant whether or not someone is encouraging sentencers to order a pre-sentence report or not. And my concern is that the way in which the Sentencing Council have gone about this is unhelpful. But I do also think, and you'll hear me expand on this, that it would be wrong to throw the baby out with the bathwater here, and that it's important also to recognise that some of the Sentencing Council guidelines are profoundly helpful to sentences, and that they indicate that we should be getting, in many, many cases, relevant information to consider individual sentencing decisions. But I think for all of those reasons, Madam Chairman, we should fetter the sentencing process only as much as we need to meet legitimate policy objectives, where it is questions of genuine policy that arise. And that, again, is, after all, what the government has said it is trying to do here. Now, Amendment 1 would allow us to stop the Sentencing Council recommending pre-sentence reports for those who simply belong to a demographic group, but not exclude them for those who have other personal characteristics which are clearly more relevant to the sentencing decision and do not, I suggest, in any way give rise to so-called two-tier justice. Now, Madam Chairman, the bill will still allow the Sentencing Council to issue guidelines recommending pre-sentence reports in order to explore the personal circumstances of an offender to be sentenced, even though it will prohibit that in relation to the offender's personal characteristics. So the question, of course, arises, can all the information about an offender that sentences should properly take into account in sentencing be justifiably described as the offender's personal circumstances? Now, I will concede, Madam Chairman, there is a danger of getting into some fairly fine semantic distinctions here, but to me at least, characteristics are those things which are intrinsic to the offender themselves. Circumstances are the situations in which offenders find themselves, and those two are not the same. So, for example, being pregnant, addicted, a primary carer, a victim of abuse, grooming or modern slavery, all could, I think, sensibly be described as personal circumstances. But disabilities or life-altering permanent injuries feel more like characteristics. But I suppose, Madam Chairman, the point is we don't need to get into all of this in order to do the job that the government wants to do. Ministers have made it clear that they are seeking to target this legislation carefully to avoid trespassing on the separation of powers, and because they are not seeking to undermine the independence of the Sentencing Council any more than necessary to wrestle back control of what are properly matters of policy. I would therefore suggest to the Minister that the more precise wording in Amendment 1, which is of course also government drafting because it appears in the explanatory notes, better meets the government's own aims than the language currently in the bill. And if he doesn't agree, I hope he will be able to explain clearly in this debate why the government have taken a more expansive approach. And finally, Madam Chairman, I want to say something about Amendment 3 in the name of my honourable friend, the Shadow Minister, and other honourable and right honourable friends, because, as my honourable friend knows, I also have concerns about the breadth of language in that amendment. Now, I recognise that some would like to abolish or radically reform the Sentencing Council, but this bill does neither of those things, meaning that its scope does not allow for a wider debate about the Council's wider purpose and value, and of course, Madam Chairman, you wouldn't allow that debate either. But it also means that as and when this bill passes, the Sentencing Council will continue to operate. So when we consider amending the bill further, we must have regard to the Council's ability to do so effectively and convincingly. The role the Sentencing Council plays in the criminal justice system can only, in my view, be played effectively if the guidelines it produces are authoritative. And sentences are only likely to see them as such if the Council itself is seen as clearly independent, making its judgments from a legal, not a political perspective. Now, Amendment 3 says that all Sentencing Council guidelines involving pre-sentence reports must be agreed by the Secretary of State. Indeed, that the Secretary of State may, if she so chooses, rewrite those guidelines herself. Well, I think there are two problems with that. The first is the Lord Chancellor has made clear and, in my view, sensible distinctions between guidelines which relate to matters of policy and those which relate, on the other hand, to matters of judicial discretion in specific sentencing cases, with the latter, of course, being matters for the judiciary alone. Now, I'm not convinced that all conceivable guidelines relating to pre-sentence reports will qualify as matters of policy. So taking political control of all such guidelines would, I think, not be appropriate. And the second problem is that the Secretary of State's approval of guidelines, and even more so, the capacity for her to rewrite the guidelines, is wholly incompatible with the independence of the Sentencing Council. The Sentencing Council could be obliged to publish in its name a guideline of which it fundamentally disapproved. In the law as it stands, the Sentencing Council must consult the Lord Chancellor and indeed the Justice Select Committee, and I see the Chairman in his place, but that is not the same as the Sentencing Council requiring ministerial approval to publish a guideline. And it is, of course, ministerial approval that is proposed in the amendment, not parliamentary approval, which are very different things. What we're engaged in here is discussing a parliamentary decision about the guidelines, not allowing a minister to make that decision for him or herself. And as I said at the second reading debate, I think that by its handling of this issue, the Sentencing Council has brought on itself both this legislation and probably a wider discussion about its own future. But we are not, Madam Chairman, having that discussion today. We are discussing legislation which is intended to allow the Sentencing Council to continue to operate and to fulfil what I believe is an important task. There is a big gap between legislation on the one hand and individual sentencing decisions on the other. The Sentencing Council fills that gap, offering help to sentencers in their role. Now, I suspect that if the Sentencing Council were not fulfilling that function, someone or something else would have to do so. And in that gap between legislation and individual cases, the closer we are to legislation, the more legitimate parliamentary and ministerial involvement is likely to be. And the closer we are to individual cases, the more danger there is of trespassing on judicial independence and the separation of powers. So we should, Madam Chairman, tread carefully. If we are to compromise the independence of the Sentencing Council in substantial ways, we should do it only having considered all the implications of doing so. And that is not what this bill allows for. It is designed to do a specific job. And indeed, I think it could do it even more specifically, hence the amendments that I have proposed. I beg to move.
The question is that Amendment 1 be made. Andy Slaughter.
Thank you very much, Madam Chairman. It's a pleasure to take part in this committee stage debate on this short bill. At second reading only a few days ago, I set out my views on the merits or otherwise of the bill, and in particular how it affects the role of the Sentencing Council, how the Council has conducted the consultation on this guideline, the response to that consultation by, in particular, the then government through its Sentencing Minister, and the then Select Committee through my predecessor as Chair, Sir Bob Neal, KC. I also regretted how the bill had been used as a means to undermine judicial independence and make ad hominem attacks on judges under the guise of belatedly objecting to the guideline. I'm not the only person to raise these concerns, and I agree entirely with the article on this matter by Sir Bob in the Times last Thursday. I don't propose to repeat any of these arguments, nor do I need to spend a long time on the amendments tabled for debate today. Those from the official opposition do no more than continue on another front, the culture war that is the obsession of the Shadow Lord Chancellor in his quest for higher office. I am more sympathetic to the new clause for in the name of the Liberal Democrat spokesperson, an important member of the Select Committee also, the Honourable Member for Eastbourne, given the fractious nature of the debate around this bill and the testy relationship between the Sentencing Council and the Ministry of Justice. It may be sensible to review the effect of the bill, but I'm not sure we need to put that into legislation. Indeed, the sentencing landscape is about to shift fundamentally with the imminent publication of the Independent Sentencing Review, swiftly to be followed by a sentencing bill. I suspect that issues raised by this bill will get swallowed up in that process, and the Lord Chancellor has indicated that it may include a review of the role of the Sentencing Council. Without wanting to stir the pot further, I observe that had the Sentencing Council been prepared to postpone implementation of the guideline without the threat of legislation, all these matters might have been dealt with in one bill and in the light of David Gauke's recommendation. The amount of time, parliamentary and ministerial, that's been spent debating a relatively narrow point could, in my view, have been better spent on other matters requiring urgent attention in our courts and prisons. Of course, I'll give way.
Sir Ashley
I'm grateful to my honourable friend for giving way. Would he accept that the reason we are here today is an error of judgment by the Sentencing Council, and they refused to back down on that until threatened with legislation? So doesn't the amendment proposed by the Shadow Justice Secretary actually offer greater protection to the public from future errors of judgment by the Sentencing Council?
Well, I said I don't want to repeat everything I said at second reading, and I think I made a case there for why the Sentencing Council had actually behaved quite properly in the way it conducted, and he was complimented by many people, including the then Select Committee, on the way it conducted its consultation. And I have a great deal of sympathy with the Council and its chair on being somewhat surprised by the reaction at this stage, it having been approved by, well, really everyone who considered it at that time. But where I am with the Right Honourable another member of the Select Committee, whose opinion I have a great deal of time for, is that I think that they were a little stubborn when confronted with the Lord Chancellor's view, as well as other members of this House, and they could have acted in order to prevent us all being here today. And as I say, when there are many other matters that need our attention. The only other observations I have at this stage relate to the amendments in the name of the Right Honourable Member for Kenilworth and Southam. As I would expect from a distinguished former Attorney General, his amendments do go to the central issue of the bill, whether as drafted it does what the government intends it to do. I hope the Minister will address in his response the issue of what a personal characteristic as opposed to a particular demographic cohort is, and what characteristics are caught by Clause 1. I will take a few minutes, if I may, to add some related questions on which I'm also seeking the Minister's guidance. Firstly, the effect of the bill on sentencing guidelines already in force. The legal effect of the bill goes beyond the imposition of community and custodial sentences guidelines and future guidelines, and would also render unlawful the inclusion of provision framed by reference to different characteristics of an offender in all sentencing guidelines by the Council that have already been issued as definitive guidelines and are currently in force. The potential retrospective effect of the bill upon guidelines already in force could create some legal uncertainty as to the lawfulness of particular guidance in guidance currently in force. There are two main examples of existing overarching guidelines in force that could be caught by the bill: the guideline on sentencing children and young people and the guideline on sentencing offenders with mental disorders, developmental disorders or neurological impairments. In relation to offence-specific guidelines, a significant number contain mitigating factors framed by personal characteristics, which have expanded explanations which refer to the need to order a pre-sentence report. For example, explanation for the mitigating factor of age and or lack of maturity in the aggravated burglary guideline. By way of another example, the explanation of the mitigating factor of pregnancy, childbirth and postnatal care in the same guideline states, when considering a custodial or community sentence for a pregnant or postnatal offender, the probation service should be asked to address the issues below in a pre-sentence report. If a suitable pre-sentence report is not available, sentence should normally be adjourned until one is available. The Minister, in a letter to the Chair of the Joint Committee on Human Rights on the 24th of April, wrote, "Once the bill is in force, any provision in sentencing guidelines that is of the description in the new subsection 4A will cease to be lawful and so cease to have effect. I can therefore confirm that the bill will, as a matter of law, affect both new and existing guidelines. In practice, this means that some existing guidelines will be affected by the bill, including offence-specific guidelines relating to mitigating and aggravating factors, which set out guidance about pre-sentence reports for specific cohorts. That, to my mind, begs several questions. Firstly, has the government determined which existing guidelines will be rendered unlawful by the bill? Secondly, why did the government decide to make the provision in the bill apply to all guidelines rather than just the imposition of community and custodial sentences guideline, which was issued by the Council as a definitive guideline on the 5th of March 2025? And thirdly, would the government be willing to limit the effect of the bill so that it did not affect the legality of any guidelines currently in force? All these matters in the interest of clarity. Secondly, there is the matter of the definition of personal characteristics that was touched on by the Right Honourable Member for Kenilworth and Southam. The bill states that guidelines produced by the Council cannot include provision framed by reference to personal characteristics. The bill then specifies that personal characteristics include, in particular, race, religion or belief and cultural background. The list is non-exhaustive and therefore also covers other personal characteristics, for example, age, disability, sex and sexual orientation. Clause 1 would therefore render unlawful the following cohorts which were included in the imposition of community and custodial sentence guideline: a young adult, female, the one we've discussed, when I think minorities, pregnant and postnatal, has disclosed they are transgender, or has or may have a serious chronic medical condition or physical disability, and there are others. Neither the bill nor the explanatory notes provides any further guidance on the intended meaning of personal characteristics. The use of the term characteristics could mean that each of the protected characteristics, as defined by the Equality Act 2010, that is age, disability, gender assignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, sexual orientation, may be caught by the provision. The chair of the Joint Committee on Human Rights wrote to the Lord Chancellor on the 8th of April and asked the following question: is the term personal characteristics in the bill intended to exclude pregnancy, motherhood and age to ensure guidelines that are consistent with case law? The reply from the Minister on the 24th of April I've already referred to is the bill specifies that personal characteristics, including race, religion or belief or cultural background. However, this is a non-exhaustive list, and personal characteristics is also intended to cover a wide range of characteristics, including sex, gender identity, age, physical disabilities and pregnancy status. Pregnancy, motherhood and age are therefore not excluded from the definition of personal characteristics. The explanatory notes to the bill state that the bill does not affect Court of Appeal case law on the circumstances where a pre-sentence report is either necessary or desirable. And it then cites 3 cases: Thompson, where a woman is pregnant or has recently given birth; Meanley, which involves young defendants; and Kermakaj, where the defendant's traumatic upbringing, vulnerability and the fact they had a victim of modern slavery meant a pre-sentence report should have been required. The explanatory notes make clear that the government does not intend to prevent the Court of Appeal or any other body from issuing guidance relating to pre-sentence reports from being framed by personal characteristics, other than ethnic, cultural, faith and minority community issues. And it would appear to indicate that it does not object in principle to such an approach. The Minister's letter makes it clear that the government objection lies with the Council taking such an approach. So, again, I ask the Minister the following questions. Why does the bill take a non-exhaustive approach to the definition of personal characteristics? Would the government be willing to narrow the effect of the bill so that only references to ethnic minority, cultural minority and faith minority community would be deemed unlawful? Could the government explain why it wishes to make it unlawful for the Sentencing Council to produce guidance to require a pre-sentence report for a defendant with a physical or mental disability. Finally, why is the government willing to accept that the Court of Appeal can provide guidance on when a pre-sentence report is needed by reference to personal characteristics, but not willing to accept the Sentencing Council doing the same thing? One final question. The effect of Clause 1 is to prevent the inclusion of guidance that is framed by reference to personal characteristics. Would the bill prevent the Council from making an indirect reference to personal characteristics through either reference to Court of Appeal case law or mitigating factors in a guideline relating to pre-sentence reports? Those are the only matters I wish to raise in relation to the amendments here today. I am concerned that there are ramifications of the proposals in this bill which have not been covered here. Now, that may be able to be corrected in the other place. It may be matters that have to wait until we have a sentencing bill in the autumn. While I entirely understand the government's frustration with the Sentencing Council, I do not feel that this particular bill is a solution to the problems that it has identified. And whereas I think the consequences have been exaggerated in many respects, I also think that if we want not only a fair and robust system, but one that is clear in dealing when pre-sentence reports are needed, that we will need to return to this on a future occasion.
Sir Ashley Fox.
Thank you, Madam Chairman. I've already recorded my support for the principle of this bill, which is unfortunately necessary to uphold the principle of equal justice. I'd like to speak today in support of Amendments 3 and 4, which further strengthen this legislation. Amendment 3 gives the Justice Secretary the power to prevent future errors of judgment by the Sentencing Council. It would require the Council to secure ministerial consent before issuing any sentencing guidelines concerning pre-sentence reports. We should be clear that this is not a measure aimed at politicising justice. We must, though, ensure democratic oversight of a body that has shown itself capable of committing such a serious error of judgment, which has led to the situation today. The reason we're legislating is because the Sentencing Council's guidance proposed treating offenders differently based on their ethnic, cultural or religious identities. And that is wrong. Happily give way.
Honourable Gentleman, the Sentencing Council at no point has suggested treating defendants differently according to their ethnicity or their religion. All the Sentencing Council has tried to do is to make sure that judges and magistrates have the maximum information.
Sir Ashley Fox.
I'm grateful to the Right Honourable Lady for her intervention. But what the Sentencing Council does say is that if, for example, you're a white Christian male, you are less likely to benefit from a pre-sentence report than if you're a member of a religious or ethnic minority. And I believe that that is wrong. Yes, I will give way.
I appreciate the Right Honourable Member giving way. But does the Right Honourable Member know that any defendant before the courts who has no previous convictions, despite the seriousness of the offence, that individual would be entitled to a pre-sentence report?
Grateful to the Honourable Member for his intervention, and yes, as a former solicitor, I am familiar with that provision, and I agree that any defendant who hasn't yet received a custodial sentence should have the benefit of a pre-sentence report. But imagine two criminals who both do have a criminal record, and one is a member of a religious or ethnic minority and one is not. These guidelines propose treating them differently, and that is not justice. Yes, I'm happy to give way.
Isn't the fact that the sentencing guidance said it would normally be considered necessary and then went on to talk about race and religion. That is the fundamental problem, making those distinctions immediately apparent when looking at sentencing guidance, which could mean that a white Christian male would be treated differently if they committed the same offence as someone from a different ethnicity.
Sir Ashley Fox.
Indeed, I'm grateful to my honourable friend for making the point. And the point I wish to make to the House is that all defendants should be treated equally. And it shouldn't be a matter of whether they are a member or not of an ethnic or religious minority. Now, the Council did not withdraw this guidance on principle. It didn't acknowledge its error. It was forced to backtrack only after public and political pressure, largely from my right honourable friend, the Shadow Justice Secretary. Even then, the Council continued to defend the policy's rationale in private communications to the judiciary. Now, that is not accountability, that is evasion, and that is precisely why Amendment 2 is so vital. We cannot allow this to happen again, and Parliament must have a say when guidance threatens the impartiality of our legal system. Equally important, Madam Chairman, is Amendment 4, which addresses the content of sentencing guidance itself. This amendment would make it illegal for sentencing decisions to consider a defendant's group identity, particularly in reference to historical discrimination that has no bearing on their individual case. Current bail guidance from the Ministry of Justice already advises courts to consider the trauma suffered by individuals whose relatives experienced racism or cultural discrimination. It even refers to important historical events and their supposed differential impact on specific ethnic or cultural groups. That approach undermines the principle that people should be judged as individuals, not as members of a group. Amendment 4 would draw a clear legal line. Mitigating factors in sentencing must relate directly to an individual's actions and circumstances. Inherited identity or injustices not experienced by a particular convicted criminal should not be relevant to the sentence passed by the court. Madam Chairman, race, religion or cultural background should not determine whether someone is sent to prison, and it should not determine whether someone should benefit or not from a pre-sentence report. The Lord Chancellor has argued that the current bill allows her to move at pace to reverse the worst aspects of the Sentencing Council's proposals. But this is not just about moving fast, it's also about ensuring we never face this situation again. These amendments are essential if we are serious about protecting the most basic principle of a free society, equality before the law. Without them, the bill addresses the symptoms, but not the cause. So I urge the House to support Amendments 3 and 4 and to reaffirm our commitment to equality before the law. Thank you.
Diane Abbott.
Madam Chair, I entirely agree with members that are making the case that we should all be equal before the law. The problem is that the statistics, the figures, show that that is not the case, and it's not been the case for decades. If you look at the figures for the numbers of people in prison, black people make up 12% of the prison population, and yet we only make up 4% of the general population. That tends to point to the concern that we are not being treated in the whole custodial criminal justice system, that we're not equal before the law. I can remember years ago, before perhaps some members were in the House, you couldn't say anything about institutional racism in the police force and how black people were treated by the police. It took Stephen Lawrence and the Macpherson inquiry to get people, politicians and people that speak for the state, to even acknowledge there was such an issue as institutional racism in the police force. On the question of the debate we've had around this, my concern is that for short-term political advantage, we're putting forward a hurried bill which carries the risk of undermining the Sentencing Council and indirectly undermining the judiciary. And I don't believe that is in the interest of our legal system. I would remind the House that these guidelines were put up to consultation. There are 150 respondents, and only 4 of them made any reference to the guideline on ethnic minorities, which is so upsetting members on both sides of the House. I would say since then, 20 organisations, including the Centre for Women's Justice, Amnesty International, and the End of Violence Against Women Coalition, have written to the Lord Chancellor saying that the consequences of ditching the guidelines could be dire. They could be dire. Amongst other things, these guidelines contain detailed advice on sentencing pregnant women and the parents of very young children. And I repeat, the guidelines are not dictating the sentence. The guidelines are only saying that there are instances, the youth of the defendant, whether it's a pregnant woman, where you want the maximum information. My view is that what is problematic about this debate and about this legislation is that it has been framed as if the real conflict is between politics and the role of our criminal justice system. I would say the real issue underlying this legislation, I know it's not a view that's shared, but my view is the real issue underlying this legislation is how seriously this House, and ministers in particular, are prepared to take the proven history of racial discrimination in our criminal justice system, and not just pay lip service, but do something about it. The poor Sentencing Council, they're scarcely young radicals. They're a group of very senior judges. But they know, as anybody with any connection with the criminal justice system knows, that there is an issue of institutional racism in the courts. And they were just, in the mildest possible way, trying to make a suggestion in their guidelines about something which might help to make sure that everybody is treated the same. And it is because, as I said right at the beginning, that I believe that everybody is not treated the same, and people outside this chamber will not understand how so many members, including so many ministers, are trying to claim that we are all treated the same. I think that if we want to hold our criminal justice system up to the light, if we want to show people that we as a House are concerned to make sure that our criminal justice system is fair and seen to be fair, then my view is that we should be accepting the guidelines that have been put forward by the Sentencing Council. Thank you very much.
Siân Berry.
Thank you, Madam Chair. And can I start by associating myself with every single thing the Mother of the House? It's just sad because I couldn't possibly live up to it. I genuinely believe this bill risks undermining efforts to make sure that equality before the law is a reality for everyone. It's going to undermine that. It flies in the face of expertise, the painstaking authoritative work of the Sentencing Council, a rightly independent body run by and for the judiciary. Madam Chair, I think it's a strange and populist bill that's undermining and delaying good, well-evidenced independent guidelines for effective sentencing that would have made our justice system more fair, not less. So I want to start my objections to both clauses 1 and 2, standing part of the bill, which is essentially opposing the bill as a whole, by commenting on the process. We have before us today a single-page bill that in its specificity and intent cannot but bring to my mind, the way in which the current President of the United States is making use of executive orders to interfere intrusively and intricately in rightly independent decision-making going on by other bodies. This is a micro bill, it micro-manages, and I worry what else we might see from this government if such an example is set today. At the second reading, the Right Honourable Member, the Shadow Justice Secretary, was not shy of telling us about his next targets, the long-standing equal treatment bench book, for example. And the Honourable Member for Hammersmith and Chiswick has outlined other guidelines that might be immediately effective if we pass this bill today. So my second objection is about the substance of the bill, primarily clause 1, because I can't believe that ministers and shadow ministers are all unaware that achieving fair and equal outcomes does not mean treating everyone exactly the same. That principle is so fundamental, I think I learned it through the round window. I can't believe they're unaware that systemic racism and unconscious bias are real things, that they do affect people at every stage of the criminal justice system still in the United Kingdom in 2025. Or that the good practice we put together must mitigate against this, or else it will compound it. I don't believe that the government as a whole thinks that the findings of the independent 2017 Lammy report are untrue, or that they and a wealth of other evidence did not demonstrate the need for guidelines of this sort that provide information to help mitigate against the impact of systemic racism and prejudice. And yet here we are, being asked to vote for legislation that essentially bans this evidence and these principles from being part of independent judicial guidelines. I shall give way.
I'm very grateful to take it in way. My concern is, and I think this side of the House's concern is, when it comes to this point, the guidance said it normally considers necessary and picked out an identity of a religion or a minority, therefore actually entrenching racism back into the system, the very aim she purports to not to want to see. That is the fundamental argument the government and this side of the House are putting forward. We don't want to see this situation made worse.
Thank you, Madam Deputy Speaker. And this, yes, of course.
Just in response to the point that's just been made, these guidelines did not pick out race and ethnicity. In fact, they listed a number of circumstances in which a pre-sentence report might be considered appropriate. Someone who's at their first custodial sentence, someone that's under 25, a woman, pregnant, primary care of a dependent relative, has said they are transgender, may have addiction issues. So far from the Sentencing Council picking out race and ethnicity, it was only one in a long list of circumstances in which the Sentencing Council was suggesting that a pre-sentencing report might be appropriate.
Thank you, Madam Deputy Chair. And to return to the original intervention, I think it is difficult for some to realise that what's gone on in these guidelines is that the definition of normal has flipped away from the male, the white, the Christian, the majority, to shine more of a light on people who are parts of minorities who might have experienced systemic problems leading up to the sentencing decision. That is the point of the guidelines. That is how we act in an anti-racist way. It's how we put together policy that mitigates against the very great problems that the Mother of the House has outlined. We know about very well. In contrast to this rushed bill, the process that led to the now suspended new Sentencing Council guidelines document was excellent. It was consulted upon widely. The Justice Committee looked at it. It was given the green light by another Conservative government, of which the Shadow Justice Secretary was a member. Before I'm intervened upon, I am very aware there was a small change made. But in essence, the same document has come forward. The same principles were enshrined in the document that was proposed and approved. There was basically consensus that more use of pre-sentencing reports should be made for people suffering from systemic injustices, that particular groups might be in greater need of them, that judges should be permitted and encouraged to ask for them in more circumstances for these groups. And I wanted to also talk about another group who, by the delay that's happened as a result of suspending those guidelines, coming forward from this bill, I don't know when we're going to get new guidelines. I think there will be more harm to people of a particular group that I care about a lot, which is women, families and children, who were all a much, much more specific focus of the new, now suspending guidelines. Now, I've worked for some years on the problems and injustices facing women in the criminal justice system. I'm very, very concerned that any delay to long overdue changes to widen further the use of pre-sentencing reports, make those reports easier for these groups, will have serious consequences for too many people with these characteristics or circumstances, however we're going to define it, but also on wider society too. I would ask the ministers to tell us today about the impact of this delay on women, families, pregnant people and those other groups named, and when we'll get new guidelines that include them, and how many people will be harmed in the meantime, because this delay has already taken some weeks. Some members of the House will be very familiar with the seminal 2007 Corsten report about women with particular vulnerabilities in the criminal justice system. Incidentally, this document does also remind us that equality does not mean treating everyone the same in its introduction. The Sentencing Council guidelines were about to help plug a gap that still remained as a result of the recommendations and themes of the Corsten report, and indeed in its commentary the Sentencing Council rightly points to deeply concerning evidence of this problem, and I'm aware of difficulties judges have had justifying delays and adjournments in order to go and get pre-sentencing reports when the old guidance pushed for often impossible same-day reporting back from the probation service and cautioned against adjournments. So with this delay to the new guidelines, will it be fully 2027, i.e. 20 years after Corsten, before the old guidelines are fully removed, and how many women might be harmed in the meantime? Now, sorry, we'll to go and find a way. As far as I can see, the Shadow Justice Secretary has scored a major win today from seizing this issue to stage another culture war ambush against another minority. And this government has, instead of standing by judges, instead of standing by important principles we've all known by for a long time, instead of simply allowing these guidelines to be trialled while concerns being suddenly raised were addressed calmly, instead they've put essentially this executive order style bill before us now for its third reading, and there was not even time available at the second reading for opponents like me to point this out. Madam Chair, I am sorry, but I believe this bill represents nothing less than a rushed and extraordinary capitulation by this government to hard right propaganda, and that people will suffer injustice as a result. It is profoundly worrying to see the government legislating in this manner to micromanage justice in ways that are led by, let's face it, dog whistles, rhyming slogans and disingenuous propaganda. I will support New Clause 1, but I sincerely hope other honourable members will join me in voting against this Trumpian bill and show our respect for the independence of judges and magistrates on these matters. I think it's vital that we do something today to stand up for evidence-led policy, judicial independence and genuine equality before the law.
Ayoub Khan.
Thank you, Madam Chair. I would like to draw members' attention to my register of interest. I am a member of the Barr. Madam Chair, can I align my comments made by the mother of this House and, of course, the Honourable Member for Brighton Pavilion? This bill and the amendments, in reality, do not tackle two-tier justice in this country. In fact, they risk entrenching it. Our justice system is founded on a principle we all claim to uphold: fairness and equality before the law. And yet today, we are being asked to support legislation that fundamentally undermines that principle. And let me be absolutely clear. This is not a matter of opinion. Lord Justice William Davis, the chair of the Sentencing Council, has written candidly on this matter. He stated, for example, defendants from minority ethnic backgrounds are statistically more likely to receive harsher sentences than their white counterparts for a similar offence. That is not the opinion of politicians or pressure groups. That is a warning from within the senior judiciary itself. And yet this bill ignores that reality. Worse still, it undermines one of the very tools designed to correct it, the pre-sentence report. Let's remind ourselves what a pre-sentence report is and what it is not. It is not the sentence itself. Sentencing decisions are rightly governed by separate judicial guidance based on culpability, harm caused, and established sentencing ranges. Those guidelines remain in place. What the pre-sentence report does is help the court understand the background and circumstances of the offender, information which is needed to establish effective pathways to rehabilitation, particularly when they have had issues such as mental health challenges, learning difficulties, or lifelong trauma. The current guidelines for pre-sentence reports were very carefully revised with the input of not just senior judges, but also leading academics and practitioners, experts in criminal justice who understand the complexities and systemic disadvantages many offenders face. Madam Chair, in this House, we routinely rely on expert testimony to shape our policy, whether it's the NHS, education, or the environment, and rightly so. Yet in this case, we are doing the precise opposite, rejecting expert opinion, dismissing data, and ignoring lived experiences. Let me offer an analogy, a parallel that speaks to health disparities. According to Public Health England and the Stroke Association, Black, African and Caribbean men over the age of 55 are almost twice as likely to suffer a stroke compared to white men of the same age. This isn't speculation, it's a clinical fact. Now, if the NHS were to implement a targeted programme to deliver early stroke prevention for this group, not a single person in this chamber would call it a two-tier health system, would call it evidence-based care, would call it fair and proportionate response to a known disparity. So why, when it comes to justice, are we so afraid to apply the same logic? I'll give the honourable member.
From the medical perspective, there would be a genetic predisposition to that. Is he seriously suggesting, when it comes to this case, that someone genetically would find themselves in the law purely because they are a black person? That is the comparison he's just made is exactly that from a medical standing point. I don't think he really would suggest that, and I certainly would be against that position.
Well, the honourable member makes this point. As a criminal practitioner who has frequented court over the last 20 years, I have seen disparities. I have seen sentencing which, in my view, was not fair. And so these are lived experiences from certain communities, which is just as important as other minorities for whatever backgrounds they have. But it is important because ultimately, who have we got that has decided that this is an important feature that needs to be counted within the sentencing guidelines? This is something that went through all the consultation. It went through the previous government. People had seen this. People agreed to it, didn't raise a concern back then. So why now? Addressing inequality is not the same as creating inequality. It is, in fact, the only way to ensure real equality, to ensure that justice is not just blind in theory, but fair in practice. I know some will argue that we need to understand the root causes of disparity, and they're right. That work is essential. But while that longer-term work is ongoing, we must act in the present. We must allow the experts to do their jobs and support the guidance that they, not we, have developed through years of experience, research and consultation. Madam Chair, this bill is not just misguided, it's regressive. I cannot and will not support legislation that sidelines expert insight, ignores data and compromises the principles of fairness that we all claim to defend in the name of political convenience. Justice must not only be done, it must seem to be done. And right now, the communities that face this disparity will no doubt be concerned with this government's approach. Thank you, Madam.
Dan Tomlinson.
Thank you, Madam Chair. First of all, I want to acknowledge that the question of disparities in outcomes in our judicial system is a real issue and one that merits serious attention. I recognise the work of the Lammy Review of 2017, as well as the conclusions of the Ministry of Justice report in 2020 tackling racial disparity in the criminal justice system, which found disparities in how people from minority ethnic groups are treated in the judicial system. It's important that these issues continue to be given the focus that they merit. However, I'm glad that this bill has passed its second reading and that we are progressing through the stages of the bill today. I am firmly of the view that it is not for the Sentencing Council to make political decisions, policy decisions on this matter, for those are the domain of politicians and must remain so. Government should be able to make political decisions and implement them, and the ballot box is the right place for us to be held to account. What I find refreshing about the continued passage of this bill today is that we're showing that politicians don't have to be jelly-like in the face of blockages to their desire to make political decisions. Though at the same time, I support the unamended passage of this bill because I think it finds a way to thread the needle with a targeted intervention, and the amendment from the Shadow Secretary of State for Justice I think goes too far and would undermine the independence of the Sentencing Council. I would give.
My honourable friend has referred to blockages. How can she describe members of this House and people in the community who are trying to stand up for a fair and just criminal justice system as blockages?
I thank you for your intervention. I do not think that anyone in this House is a blockage. Far from it. The point I'm making here is that I believe that this House should be the place where political decisions are made, and politicians should be the people who decide the important things that matter to people in this country. And it's my view that the Sentencing Council is an important body, but that crucially it is not a political one. And I think that if these guidelines would have gone through, it would have undermined the important principle of the equality before the law. And of course that is a political decision. There are differences across and within different sides of this House, but that's for us to contest here in this place. I'm glad that this government is making sure that we can make progress on the things that we believe need to be pushed forward for the British people, and I hope that the bill will pass unamended today, because the precise changes it proposes allow for sentencing guidelines not to be changed in ways that undermine equality before the law. And I do not think that the amendments proposed by the opposition are necessary. I think they take things too far. With this and with much else besides, Madam Chair, it's time for us to show that moderate politics, the politics of this government, doesn't have to be like soup, weak and watery and impossible to hold on to, but instead it can be a politics of action and of delivery. So I welcome the passage of this bill, the continued passage of this bill, and urge members to vote for it today.
I now call the Liberal Democrat spokesperson, Josh Babarinde.
Thank you, Madam Chair. I made the Liberal Democrat position on this very short bill and this issue more widely abundantly clear in the last debate that we had on this matter. We believe in equality before the law, we believe in the rule of law, and we believe that no one is above the law. And that's why we believe on the matter of pre-sentence reports that anyone facing the prospect of a custodial sentence should be the subject of a pre-sentence report. We believe the state has this duty before dispensing its power to deprive someone of their liberty. There is no world in which judges and magistrates having more information about an offender and their circumstances, whoever they are, is a bad thing. That's why it is an injustice that the use of pre-sentence reports has fallen from 160,000 in 2015 to just 90,000 by 2023, a cut of 42%. And this has left judges and magistrates with fewer resources and insights than ever to go about their work. And less informed sentencing means less satisfactory sentencing outcomes. It means more reoffending, it means more victims, it means more turmoil, and that is unacceptable. That is not justice. And this is a product of underinvestment in our probation service, which compiles the reports, which was gutted under the Conservative government. I welcome, therefore, that the Minister has agreed with me in his closing speech at second reading that this debate should be about how we move to the universality of pre-sentence reports and not about rationing. And I'll come to new clause 1 shortly in pursuit of that. Of course.
I'm grateful to my honourable friend for giving way. He will be aware that any sentencing magistrate or judge can request a pre-sentence report. His use of the word rationing, I would say, is inappropriate.
The honourable member for his intervention. I don't know whether he's read the Sentencing Council's summary of the responses to the draft guidance that was in consultation under the Conservative government. But what was paraphrased from magistrates and judges is that they felt that driving a universality of pre-sentence reports would be challenging in light of the limited resource that the probation service has and in light of the court backlogs that exist. And I would suggest that he consult that document to see those phrases that have been used by those legal professionals.
Would you give way on that point?
Of course.
I'm very grateful to the Liberal Democrat spokesman for giving way. How much would that cost for the universality then? Have the Lib Dems calculated how much it would cost?
As the honourable member who just intervened is making his point that these reports should exist come what may, this cash should be ring-fenced. It should be earmarked for the use for judges and magistrates to request. Both members cannot have it both ways. What we also know is that if we best tailor a sentence to whether it will best result in somebody reoffending or not, we best match a sentence to an offender. We can spend to save. If we can reduce reoffending by ensuring that people get the appropriate sentence, we keep people out of our prisons that are crumbling and that don't need to be there because they haven't reoffended in the first place. We can spend to save. But I regret that this issue has become a political football and one that is sowing seeds of division. Plainly and simply, this is about the Shadow Justice Secretary attempting to hijack our criminal justice system for his own political ends. So desperate is he to score political points that he uses his platform in this House to undermine judges by name in the full knowledge that they cannot respond and in the full knowledge that there is a formal process by which judicial complaints can be investigated and addressed. So desperate are they to score political points that they paint judges as activist villains, working to undermine public confidence in them, just because he doesn't agree with their ruling.
I would expect the spokesman to at least acknowledge that the references to the judges are in their capacity as leaders of the Sentencing Council, not as judges sitting over individual cases, and that is an important distinction to make in terms of when parliamentarians here make comments on their conduct.
I would refer the honourable member to comments that the Shadow Justice Secretary made, I think, at the last Justice questions that he was not in attendance for, where the Shadow Justice Secretary named a specific judge, made a critique of them, a complaint of them outside the formal processes. Yes.
I thank the honourable member for giving way. Judges have been vilified, as have other members that sit on that sentencing council by members of this House. Does the honourable member agree with me? If there is to be any vilification, it's the members that sit, which form the previous government, that had the consultation given to them and agreed it.
I thank the member for his intervention. I don't agree that vilification is the right approach from any side of this argument. This debate should be conducted with respect and with good courtesy. But I feel that that was missing from some of the comments that I referred to in what I just suggested. But absolutely, there must be accountability. And indeed, the last government was held accountable in huge respect at the last general election, where they suffered the biggest defeat in their history. But so desperate, thirdly, is the Shadow Justice Secretary to rise to the top of our democracy that he is prepared, in the ways I've described, to undermine our democracy itself. And turning to the specifics of this bill, it's been referred to already by other honourable members, but this bill and its amendments are rushed, knee-jerk, and not the way to make policy about people's liberty, nor our constitution. As I've said before, why not negotiate with the Sentencing Council now that the immediate emergency has subsided? To my knowledge, based on my engagement with MOJ, ministers and officials, the question hasn't been asked as to how long they'd be prepared to pause for before they would implement their guideline. As I've said before, why not wait for the Gork review to report and ensure that this issue is explored comprehensively and ensure that wider consultation takes place? And as I've said before, why not comprehensively address what is already a two-tier justice system that has been referred to by some members behind me, and indeed the mother of the House, where, for example, people from ethnic minority backgrounds, as the Lammy Review found, are more likely to serve longer sentences for the same crimes as people who are not from ethnic minority backgrounds. It's disappointing that there's no provision in this bill to look at this. And if the government does insist on passing this bill, we urge the government to embrace our calls for an independent review of pre-sentence reports to be conducted within 2 years, as per new clause 1.
Yeah. I hope the honourable member was listening to my speech when I talked about the harm that might be caused from the delay in bringing in the really excellent parts of the new guidelines that might help women and families. Are the Liberal Democrats asking for a delay, or would they like to support bringing in the parts of the guidance that are agreed as soon as possible?
As I've just said, one of the problems with these proposals is consultation has been minimal. These come from a rushed place. These come from a place of responding to a culture war. We're making decisions here, or we're voting on things here about people's liberty or not. And I think we need to consider those issues in great detail before responding in a knee-jerk way. But what I absolutely can say, though, and what I have discussed with members of this House, including the Lord Chancellor, that the provision, for example, when it comes to pre-sentence reports in this guidance around victims of domestic violence, modern slavery, etc., their circumstances should be considered. And as I've said actually at the very beginning of my speech, pre-sentence reports, we should lean toward a presumption of universality rather than one of rashness. So all those groups that have just been mentioned and more can access, or judges can access, a pre-sentence report on those individuals. Now, we make the call that I've just made not only because we have grave concerns about the impact of the proposed changes, but also because we remain steadfastly committed to evidence-based policy making. And against the backdrop of cynical culture wars and leadership manoeuvres, it's more important than ever for the government to assess the outcomes of this policy. Assessments based on statistics, data and evidence, as opposed to dogma and ideology. To conclude, we must not dance to the tune of the populists or the culture war fanatics, nor undermine our legal institutions. As such, our position has not changed since last time, and we will act accordingly. We will defend our judicial system and its independence, but we reject short-term reforms that fail to address the wider issues of disproportionality at play.
I call Shadow Minister Dr. Kieran Mullan.
Thank you, Madam Chairman, and I rise to speak in support of Amendments 3 and 4 on the amendment paper in my name, in the name of the Shadow Secretary of State for Justice and Conservative colleagues. As MPs from across the House have already made clear, the draft guidelines produced by the Sentencing Council would have led to an unacceptable two-tier justice system. One where defendants were treated differently, not based on their crimes, but based on their racial, cultural or religious identity. In fact, the record will show for several hours two-tier justice did exist because this issue was so shambolically managed that the guidance came into effect ahead of its withdrawal formally. That's not just it, it's a betrayal of the fundamental principle of equality before the law. And it would have happened under the watch of this Labour government and the Lord Chancellor, but for the intervention of these opposition benches and in particular the Shadow Secretary of State for Justice. Madam Chairman, this bill is necessary but is not sufficient. Instead of acting decisively to restore public confidence after the Labour government has been dragged to this place to act at all, it now brings forward a half measure, a meagre response that falls short of what it should be. That is why the opposition has tabled two important amendments. First, Amendment 3. This amendment would ensure that in future, sentencing guidelines concerning pre-sentence reports cannot simply be issued by the Sentencing Council without democratic oversight. They would require the consent of the Secretary of State before coming into force. Why is that now necessary? Because the Sentencing Council has proven itself not just in the initial measures it proposed, but in its attitude and response towards parliamentary and public scrutiny, unable to sustain public confidence in its work in this area. It's one thing for a public body to possess operational independence and to seek to exercise that independence on a day-to-day basis. It's quite something else when a public body chooses not to exercise good judgment, to make use of that independence to act with restraint in the face of widespread government opposition, parliamentary and public concern. Whilst they of course can have their merits, the actions of the Sentencing Council brought to life the potential pitfalls of unelected quangos that are deaf to the concerns of the people who pay their wages and the politicians who represent those people. While this whole affair has no doubt been a humiliating one for the Lord Chancellor and the government, the damage to the public confidence in the leadership of the Sentencing Council is just as great. Despite what the Liberal Democrat spokesperson has said in his remarks earlier in its second reading, the Sentencing Council did not agree to pause the implementation of the guidelines to allow for a period of reflection. It outright refused to do so, and he's misunderstood the sequence of events. It only paused because otherwise we would have entered into a constitutionally unsustainable situation where people were being sentenced in the courts with guidelines being legislated against in Parliament through emergency legislation. It was that direct threat alone that caused them to pause and demonstrated their lack of judgment. And so I'm afraid we must act more broadly to constrain the Sentencing Council in future, pending any wholesale changes that may be forthcoming. That is why the Shadow Secretary of State put forward a bill that would have taken the necessary step to return accountability of the body through the Lord Chancellor, whilst wholesale reform could be undertaken. Labour chose to oppose that bill. Today, it is out of scope for us to seek to introduce a similar wide amendment, and so we are restricted to at least seeking to restore accountability where we can in this field. Our amendment would require that where the Council drafts guidelines on pre-sentence reports, those guidelines must be expressly approved by the Secretary of State before they come into force as definitive guidelines. That is a basic safeguard of democratic accountability, ensuring ministerial oversight on sensitive matters of sentencing. Without our amendment, history can repeat itself. The same Council will be free to bring forward ideological frameworks that ministers will be powerless to stop before the damage is done. Had these guidelines gone unchallenged, we would have tilted sentencing based on identity politics, undermining public confidence in the entire system. Our amendment would create a crucial safeguard ensuring that no future set of guidelines, in this field at least, could bypass ministerial accountability. I would encourage members on the government benches who've made clear they want to see accountability restored across the work of the Sentencing Council to vote in support of the amendment today. To do otherwise will make clear that they are unwilling to follow through on their concerns with action. Our second amendment, Amendment 4, would make clear that sentencing guidelines about pre-sentence reports must not include consideration of defendant status as part of a group that has experienced historical or intergenerational trauma. Why is this necessary? Because it would be deeply wrong to allow collective historical grievances to influence the sentencing of an individual today. This area is the latest frontier of identity politics, when the public in all sorts of domains is being told that what should be given disproportionate focus, that what matters more than what's happening today, and the whole variety of challenges facing people of all creeds and colours is in fact the past. Sentencing must focus on the actions, culpability and the direct personal circumstances of the defendant before the court, not on sweeping assumptions based on historical events. We are not able in this bill to legislate across all the workings of the criminal justice system as much as we might like to. The events of the past few months show that what has happened with these guidelines was not a one-off. There is a creeping systemic attempt to inject identity politics into our judicial processes, into bail decisions, into probation, even into training materials. If we do not confront it now, it will embed itself deeper and deeper into the foundations of our system. Madam Chairman, it is fundamental to the rule of law that justice looks to the individual, not to the group. It's fundamental that we deal in evidence, not in ideology. Taken together, our amendments are designed to strengthen this bill, to ensure that it's not merely a reactive measure, but in this narrow area at least, provides lasting protection on the principle that justice must be blind and must be seen to be blind. The public expect justice to be equal, not preferential. Our amendments would go further in helping to secure this. We're here today because the Lord Chancellor was not paying attention and was then humiliated by the recalcitrant leadership of an unelected body turning their face against parliamentary and public concern. They should have acted decisively, immediately, and we provided an opportunity for them to do so, and they failed to take it. Even now, we are faced with a bill that doesn't do the full job. Our amendments are closing the gap between what the Lord Chancellor is offering and what is necessary, decisiveness in place of timidity, and I urge the whole House and the Government to support them.
I call Minister St Dakin.
It's a pleasure to serve with you in the chair, Mrs Cummings. I would like to thank the Honourable and Right Honourable members present here today for the points they have raised and the amendments which have been discussed, which I will respond to in turn. First, I will speak briefly to each clause of the bill and remind us of why we are here debating this bill. In the last Parliament, the Sentencing Council consulted on a revised imposition guideline, which was due to come into effect on the 1st of April this year. The revised guideline includes additional guidance on when courts should request pre-sentence reports. It notes that pre-sentence reports will normally be considered necessary for certain offenders, including those from an ethnic, cultural or faith minority. Normally be considered necessary, replaced may be particularly important, which the previous government very much welcomed. This government notes that a pre-sentence report is necessary. This government agrees that disparities exist in the criminal justice system. However, the reason for this are unclear, and this is a matter for government accountable to Parliament and to the ballot box to address, which members have noted during this debate. In effect, the revised guideline could have led to judges deciding whether to request a pre-sentence report based on an offender's faith or the colour of their skin. The Lord Chancellor has been clear that this would be unacceptable, as it risks differential treatment. Singling out one group over another undermines the idea that we all stand equal before the law, a principle that has been in the foundations of our justice system for centuries, and that's why she acted immediately and quickly. By preventing the Sentencing Council making guidance on pre-sentence reports with reference to personal characteristics, this bill helps ensure equality before the law. Clause 1 amends Section 120 of the Coroners and Justice Act 2009. It provides that sentencing guidelines may not include provision framed by reference to different personal characteristics, including race, religion or belief or cultural background. Therefore, any existing guidelines that make reference to different personal characteristics will cease to have effect, and the Sentencing Council is prevented from making such provisions in guidelines in the future. The changes made by this clause prevent the Sentencing Council making policy about when pre-sentence reports should be obtained that risks differential treatment before the law, and which could undermine public confidence in the criminal justice system. The Sentencing Code is clear that courts should obtain pre-sentence reports unless, in the circumstances of the case, it is unnecessary. This clause does not affect the independent judiciary's ability to make decisions based on the personal circumstances of an individual offender or determine where pre-sentence reports are necessary or desirable. Nor does it stop the Sentencing Council from advising in general terms that pre-sentence reports are sought in cases where the court would benefit from an assessment of an offender's personal circumstances. We expect there will...
Pre-sentence reports, as you've been setting out, are really important in considering punishments that can address offending behaviour and help reduce the likelihood of reoffending. But very often probation is stretched so thin that officers don't have time to complete them. So what is the Minister doing to ensure that where a pre-sentence report is required, probation has the capacity to do that important work?
I thank my honourable friend for her intervention, and she echoes much of which the spokesman for the Liberal Democrats picked up earlier. Probation is a very significant part of the landscape, and that's why we're onboarding 1,300 more probation officers over the next year. So the honourable member, the chair of the Select Committee, raised issues about the impact of these guidelines on existing guidelines, and we expect there will be other guidelines that will be affected by the bill, and these include offence-specific guidelines related to mitigating and aggravating factors, which set out guidance about pre-sentence reports for specific cohorts, and we will continue working with the Sentencing Council on the implementation of the bill. We've had constructive discussions and will continue to do so. As he referenced the bill's explanatory notes, it point out that it does not change existing precedent where the courts have determined that pre-sentence reports are necessary or desirable in cases such as Thompson, where the Court of Appeal recently emphasised their importance in sentencing pregnant women or women who have recently given birth, Meanly, in which the court referenced the value of pre-sentence reports for young defendants, or Kermaki, where the defendant had a traumatic upbringing, vulnerability and was a victim of modern slavery. Instead, the bill narrowly focuses on the issue at hand, putting beyond doubt the principle that we all stand equal before the law of the land. Clause 2 is concerned with details about how the bill will be enacted. The bill will apply only to England and Wales, and its measures will come into force on the day after it passes. The bill may be cited as the Sentencing Guidelines Pre-Sentence Reports Act 2025 once enacted. I would like to thank the Right Honourable Member for Kenilworth and Southam for tabling his amendments and for the very thoughtful and comprehensive way in which he dealt with them, and I will deal with them together. Amendments 1 and 2 would replace the term personal characteristics with demographic cohort to describe the type of provision that pre-sentence reports in sentencing guidelines that the bill will prohibit. The Government has considered the proposed change to the wording very carefully and would like to take this opportunity to briefly explain the Government's approach. The Government's objective is to help ensure equality before the law so that offenders are treated according to their own particular circumstances and not by virtue of their membership of a particular group. So to ensure the bill prevents sentencing guidelines about pre-sentence reports, including provision framed by reference to any specific personal characteristics of an offender, we have used the term personal characteristics. The bill sets out that personal characteristics include race, religion or belief or cultural background. However, this is not an exhaustive list. We accept that personal characteristics and personal circumstances have over the years been elided in different court judgments, and we are clear that it is intended to cover a wider range of characteristics, including sex, gender identity, physical disabilities and pregnancy status. The Right Honourable Member has rightly noted that the term demographic cohort is used in the bill's explanatory notes. However, the use of demographic cohort was not intended to, and I believe does not narrow the definition of personal characteristics, though I note that he believes it might do. Rather, it is a different term used to describe individuals who share certain personal characteristics.
For giving way. For the purposes of clarity then, and I accept that he's trying to give us clarity, can he help us with this? Is it the Government's view that all personal characteristics can also be described as personal circumstances?
No, that's not the Government's view. Personal characteristics is a term that's understood and applied in other contexts, whereas demographic cohort is a term that, on balance, the Government feels is more imprecise and would ultimately need to be defined with reference to a group with shared personal characteristics. It's therefore, from the government's point of view, though I understand where the honourable member is coming from, but from the government's point of view, it doesn't add anything to the drafting of the current bill and risks causing further confusion. So as he pointed out in his very helpful contribution, there's a danger of getting into detailed semantics here, which probably doesn't help any of us. And if
this warning, and I'm not sure this is going to make it any better, but I think what he's saying then is that the question of the term demographic cohort is a subset of personal circumstances. Subset of personal characteristics, but personal characteristics are not the same as personal circumstances. I think that's what he's saying. Is that right?
I think what I'm saying is that if we use the phrase demographic cohort, we then have to define what demographic cohort means, whereas personal characteristics is a phrase that already has a level of definition and therefore is one that is preferred by the government. If I can just turn on to my honourable friend, the member for Hammersmith and Chiswick, about the similar issue that he raised. We carefully considered whether the bill could and should be narrower than referring to personal characteristics, for example, an offender being from a cultural minority, but in the end we felt that was not helpful. So as such, while I'm very grateful to the Right Honourable Member for suggesting alternative wording, the government remains of the view that, having considered it very carefully, the term personal characteristics is the most appropriate way of capturing the issues raised by this guideline.
Could you just clarify the point, for example, in relation to pregnancy, where he said clearly, it's in the explanatory notes, that it would be right for a census to follow Thompson, i.e. ordering a pre-census report where a woman is pregnant or has recently given birth, but it is incorrect for the Sentencing Council to make recommendations along those lines for sentences to follow that, following the passage of this bill. I don't quite see the difference.
I think the made it clear, and that, as he says, it's right to follow Thompson in those circumstances. So, while I'm grateful to the Right Honourable friend, member for raising this issue and rightly exploring this issue on the floor of the House, I hope that he doesn't push the amendment to vote. Moving on then, Amendment 3, tabled by the Right Honourable, tabled by the official opposition, would require the Sentencing Council to obtain the Secretary of State's approval before issuing any sentencing guidelines about pre-sentence reports. I referenced the very helpful words of the Right Honourable Member for Kenilworth and Southam when he said we should tread very carefully in this territory and that the separation of powers need to be very much respected. So, whilst carefully considering the case for mandating that the Sentencing Council obtain the Secretary of State's approval, I'm not persuaded that this is appropriate at this particular time. As the Lord Chancellor set out, this case has highlighted that there is potentially a democratic deficit here. That's why we're currently assessing the Sentencing Council's wider role and powers for developing sentencing guidelines and recent developments and imposition guidelines in mind. I give way.
I gently suggest to the Minister, if there's a risk of a democratic deficit, surely the thing to do is to act now in the short term and unpick it later if he feels he's overreached.
Quite right.
We certainly don't feel we've overreached. We're acting in a timely and effective way. And as this debate today has demonstrated, there are issues of detail which need to be properly explored. The Lord Chancellor has done the right thing in announcing a review of what's sentencing, having a look at things in proper time, and that will take place. Given the special role of the Kent Sentencing Council and significant policy and constitutional issues involved, it is right that we take the time to consider whether more fundamental reform is needed, alongside considering wider recommendations that come out of the independent sentencing review. I'm not convinced it would be proper to deal with the issue now through this fast-track legislation, nor am I convinced that legislating in a piecemeal way would be helpful, noting that the Right Honourable Member's amendment just applies to sentencing guidelines about pre-sentence reports, and there may be other things we need to look up. But to be clear, we are keeping all options on the table and willing to further legislate on this in a more comprehensive way if necessary. I therefore urge the Right Honourable Member to withdraw his amendment. Amendment 4, also tabled in his name, would prevent the Sentencing Council from framing sentencing guidelines about pre-sentence reports with reference to groups that may have experienced trauma from historical racism or discrimination. Whilst we have carefully considered the case for adding this restriction on the face of the bill, we're not persuaded that it's necessary. Within the bill, we have taken a general approach to preventing sentencing guidelines about pre-sentence reports from being framed by reference to any personal characteristic of an offender. The bill specifies that personal characteristics include race, religion or cultural background, but this is not an exhaustive list. More widely, I appreciate the Right Honourable Member has taken a keen interest in wider guidance access across prisons and probation that touches on different experiences, including those specified within the text of the amendment. The Government is absolutely clear on the need to ensure equality before the law, and wider work is going on to review relevant policy and guidance, and we will update practices where necessary. I therefore urge the Right Honourable Member to withdraw this amendment. I now want to turn to new clause 1. New clause 1 would require the Secretary of State to arrange an independent review into the restrictions the bill places on the Sentencing Council's ability about pre-sentence reports which are framed by reference to offenders' different personal characteristics. I'd like to thank the Honourable Member for Eastbourne for tabling this amendment. Whilst we've carefully considered the case for such a review, and I of course agree that it's important to carefully think through what the effects of the bill will be, I'm not persuaded that a review is necessary because the direct changes made by the bill are very limited in nature. To recap, the bill helps protect equality before the law by ensuring no offender receives differential treatment regarding pre-sentence reports based on their personal characteristics. That reflects a fundamental principle which does not need to be reviewed. The bill does this by restricting the powers of the Sentencing Council to issue sentencing guidelines about pre-sentence reports. It will prevent guidelines from, for example, creating a presumption around whether a pre-sentence report should be obtained based on an offender's personal characteristics rather than all circumstances of the offender before the court. For the avoidance of doubt, this Government supports the use of pre-sentence reports, and we have publicly committed to creating more capacity in the probation service to ensure it is able to do the valuable work, including preparing pre-sentence reports. We were also very happy to continue to work with the Honourable Member going forward regarding disparities in the criminal justice system and the use of pre-sentence reports more generally. We fully support the increased use of PSRs in our court system. PSRs include an assessment of the offender's behaviour and the risks they pose and recommendations for sentencing options. It's a valuable tool, as many Honourable and Right Honourable Members have said, in helping to ensure the sentence is tailored to an individual offender and their circumstances. Equality before the law is a fundamental principle of our criminal justice system. It's the Government's policy and belief that this should be protected. And I welcome again the contribution from the Mother of the House, supported by both the Member for Brighton Pavilion and the Member for Birmingham Barr, to keep our feet to the fire on tackling disproportionality. I can confirm again that this Government takes very seriously tackling disproportionality in the criminal justice system, and that's why the Lord Chancellor has commissioned a review of the data on disparities in the justice system in order to better understand the drivers of the problem. And I know that my Right Honourable friend does not need my encouragement to keep going on this one, and so I look forward to her keeping us to account as we continue to move forward. I should also be clear that on what the bill does not do, to underscore its limited changes. Nothing in the bill restricts the court's pre-existing ability to request pre-sentence reports, nor the Sentencing Council from advising in general terms that a pre-sentence report should be sought where a further assessment of the offender's personal circumstances would be beneficial to the court. The bill also does not affect Court of Appeal case law about the types of cases where pre-sentence reports are necessary or desirable, as we have covered previously. There is recent relevant case law covering vulnerable defendants, pregnant women and women who have recently given birth, and young defendants. The bill will also not prevent judges from requesting pre-sentence reports in cases where they ordinarily would, including in appropriate cases involving, for example, pregnant women, as well as those involving young people or domestic abuse. And I welcome the comments from my honourable friend, the member for Chipping Barnet, on these issues. With these considerations in mind, the Government does not consider the proposed review to be necessary, but as the Lord Chancellor has set out, she is now carrying out a review into the wider role and powers of the Sentencing Council, and so I can reassure the honourable member that there will be further opportunities to discuss issues surrounding the Sentencing Council in this House, and I hope that he will therefore withdraw the amendment. Thank you, Mrs Cummings.
Sir Jeremy Wright to wind up.
Thank you very much indeed, Madam Chairman. I think, in gratitude to all those who've spoken, that we've got to a place where the Minister has told the House that there is some territory which at the moment is being described as personal characteristics into which the sentencing guidelines may not trespass. That is not the same as specifically referring to someone's personal circumstances and is a broader area than the question of whether they are a member of a particular demographic group. Can I simply say to the Minister, before this bill completes its progress, that he may want, and his departmental colleagues may want, to clarify what territory specifically now the Sentencing Council cannot construct guidelines about, so that we all understand, including the Sentencing Council, where we stand. But I'm grateful to him for the explanation that he's been able to give today, and in consequence, I'm content to withdraw my amendment.
Your pleasure that amendment be withdrawn. The amendment by leave withdrawn. We now come to Amendment 3 to Clause 1, which it has been convenient to be selected for a separate decision. I call Dr Kieran Mullan to move Amendment 3 formally. The question is that Amendment 3 be made. As many as are of that opinion say aye. Aye! Of the contrary, no. No! Division, clear the lobby. The question is, as on the order paper, as many as are of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Jerome Mayhew, Rebecca Smith. Tellers for the noes, Anna Montmorin, Taiwo Owatami. Order, order.
The ayes to the right, 86. The noes to the left, 222.
The ayes were 86, the noes were 222, so the noes have it, the noes have it. Unlock. We now come to Amendment 4 to Clause 1, which has been selected for a separate decision. I call Dr Kieran Mullan to move Amendment 4 formally.
I beg to move.
The question is that Amendment 4 be made. As many as are of that opinion say aye. Aye! Of the contrary, no. No! Division, clear the lobby. Sorry. As on the order paper, as many as are of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Jerome Mayhew, Rebecca Smith. Tellers for the noes, Anna Montmorin, Taiwo Owatami. Order, order.
The ayes to the right, 88. The noes to the left, 226.
The ayes were 88, the noes were 226, so the noes have it, unlocked. With the leave of the House, I shall put the question on clauses 1 and 2 together. The question is that clauses 1 and 2 stand part of the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. Order, order. The question is that I do report the bill to the House. The question is that I do report the bill to the House. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. Order, order. Order. Whip to report.
I beg to report that the committee has gone through the bill and directed me to report the same without amendment.
Minister to move third reading.
I beg to move that the bill be now read a third time. Madam Deputy Speaker, let me first take this opportunity to thank all members of this House who have spoken in support of this important bill. I'm particularly grateful for the support expressed at second reading, as well as all the honourable and right honourable members who have contributed to this afternoon's committee proceedings. It's not yet a month since the Sentencing Council's imposition guideline was due to come into effect. Following up, the Lord Chancellor followed up her concerns immediately with action, as members from both sides of this House have acknowledged, had the government not acted quickly to introduce this bill, the guideline would have risked differential treatment before the law in this country. I'd like to put on record my thanks to the Sentencing Council and particularly their chair, Lord Justice William Davis, for the constructive conversations on this issue and for pausing the guideline while Parliament had its say, as it is doing today. I'd also like to thank officials who've worked on this bill, including Andrew Waldron, Stephen Toll, Jack Hickey, James Meta, Claire Taylor and the bill manager, Catherine Ridley, and my excellent private secretary, Emily Brougham. This government strongly supports the use of pre-sentence reports, which judges are required by law to obtain, except in circumstances where they consider such a report to be unnecessary. We also acknowledge that there are disparities within the criminal justice system which must be addressed. However, these are matters of policy, and it is right for the government to seek a policy response to these issues. That is why we brought this bill forward today. I therefore commend this bill to the House, Madam Deputy Speaker.
The question is that the bill be now read the third time. Shadow Minister Dr Kieran Mullan.
Thank you, Madam Deputy Speaker. It's a pleasure to speak on behalf of His Majesty's opposition in this third reading debate following on directly from the Committee of the Whole House, where the Government MPs rejected our amendments to strengthen this legislation. We now know the strength of the appetite on the Labour benches opposite to really tackle this challenge properly and comprehensively here and now. We now know there isn't one. In truth, we knew this already. They had an opportunity weeks ago to restore democratic accountability to the Sentencing Council through my right honourable friend, the Shadow Secretary of State for Justice's bill. They rejected that opportunity, and they've rejected even the more modest strengthening available to them earlier today. This shouldn't be a surprise. The party opposite has a Prime Minister that is first and foremost a lawyer, not a leader, and a lawyer steeped in the philosophy of securing political change through legal activism, the very sort of approach the Lord Chancellor has been forced to bring in emergency legislation today to curtail. That is why the appetite for proper action is so limited, because the legislation before the House today is a fig leaf to hide the truth that a Labour Party led by Keir Starmer will always have to be dragged kicking and screaming to tackle judicial activism that he has long championed. And
Order. The Shadow Minister must be heard. Shadow Minister.
Thank you, Madam Deputy Speaker. They don't want to hear it. And that is why this issue has at its root cause. He appointed an Attorney General, the government's own law officer, who is steeped in judicial activism. The Prime Minister himself practised in the chambers that relished it and wholeheartedly supported to expand it case by case. For anyone interested in a treatise as to the risk of this approach from someone much more qualified than I am sure you'll agree, I would encourage you to listen to Lord Sumption's brief lectures. His analysis as to the divide between matters that should properly be the domain of politics and matters for law could not be more pertinent, and he says this: "It's a vice of some lawyers that they talk about law as if it was a self-contained subject, something to be examined like a laboratory specimen in a test tube, but law does not occupy a world of its own. It's part of a larger system of public decision-making. The rest is politics, the politics of ministers and legislators, of political parties, of media and pressure groups, and the wider electorate." He goes on to say the courts have developed a broader concept of the law which greatly enlarges their own constitutional role. They've claimed a wider supervisory authority over the other organs of the state. They've inched their way towards a notion of fundamental law overriding the ordinary processes of political decision-making, and these things have inevitably carried them into the realms of legislative and ministerial policy. To adopt the famous dictum of the German military theorist Clausewitz about war, law is now the continuation of politics by other means. Be in no doubt, this whole sorry episode has been an exquisite further example of this mentality, this time by the Sentencing Council and its members as part of the wider judicial establishment. The Lord Chancellor has failed to act decisively today. If she continues to refrain from taking decisive action, we will be here again and again, with the opposition making sure each and every step of the way that voters know where the sympathies of the Labour Party and its leader lie, not with the ordinary law-abiding citizen who expects equal treatment under the law, and for the democratically elected politicians of this country deciding on policy, but with activists and campaigning lawyers who want to wrestle control from them. The legislation before us today at third reading is barely adequate, barely. We won't oppose it as it's better than nothing. But at least, Madam Deputy Speaker, at least it tells the public everything they need to know about who sits on the opposite benches and the mentality of the man leading them.
The question is that the bill be now read the third time. As many as are of that opinion say aye. Aye! Of the contrary, no. Aye! Division, clear the lobby. The ayes have it. Division, clear the lobby. The question is, as on the order paper, as many as are of that opinion say aye. Aye. Of the contrary, no. No. The tellers for the ayes, Anna Morin, Taiwo Owatami. Tellers for the noes, Ayoub Khan, Ellie Chowns. Order.
The ayes to the right, 214. The noes to the left, 3.
The ayes were 214, the noes were 3. So the ayes have it, unlocked.